Hello, I'm Sarah Twist, an associate at ACM, and today I'm going to discuss the changes coming to charities with the implementation of the Charities Act 2022. Whilst not having a major impact on the day-to-day operations, these measures have been designed to simplify certain areas of regulation and will give trustees more flexibility to manage their charity more effectively. The changes are coming in stages, with the first tranche coming into force in autumn 2022. Key changes coming into effect this autumn include payments to charity trustees. Charities already have a statutory power to pay trustees for providing services beyond their usual trustees' duties and for goods connected to that service. This power is being extended to allow for situations where just goods are provided to the charity. For example, perhaps supplying stationery or equipment. Sometimes there are requests to make a moral or ex gratia payment from the charity's funds, or to waive the charity's right to receive those funds. The most common occurrence is when a charity receives a legacy and there is evidence that the donor had changed their mind since making their will. The new powers introduced enable charities, where trustees could be regarded as being under a moral obligation, to process requests for small amounts without applying to the Charity Commission. There are limits on how much money can be waived, which depend on the gross income of the charity. The cap will be £20,000 for the largest charities and £1,000 for the smallest. Where a fundraising appeal raises too much or too little for the intended purpose, under the new provisions, there is greater flexibility to reapply these donations to similar charitable purposes rather than returning them to the donor. This applies in certain situations, including where the donations are small, £120 or less. There is an unreasonable expense to return the donation, or where donors cannot be found or identified. For example, where donations come from a collection tin. The complexity surrounding what trustees need to do in these situations has been reduced. Where the donations are less than £1,000 and can be spent on alternative purposes, trustees can act without the Charity Commission's involvement if they comply with the new requirements. Spring 2023 is expected to see the introduction of the following additional measures. Most legal restrictions on how charities can use permanent endowment funds will remain. However, there is planned greater flexibility in some areas. A new power to borrow from a permanent endowment will be available without the requirement to obtain permission from the Charity Commission. Certain rules will apply, including restricting the maximum borrowing from an endowment fund to 25% of the value of the fund. In addition, there must be arrangements in place to repay the capital within 20 years, and the repayment needs to include an element of capital appreciation based on a relevant index such as RPI or CPI. For land transactions, charities will have access to a wider choice of professional advisors, and some of the rules on what advice they need to take before buying or selling land have been simplified. In certain situations, external advice from a qualified professional will no longer be mandatory. In addition, if the charity has a suitably qualified trustee or employee, they may provide the relevant advice without the need to instruct an external professional. Where the Charity Commission deems that a name is the same or too similar to the name of another charity, it will be able to direct a charity to change its working and legal name or delay the registration of a new charity. The autumn of 2023 is expected to see further measures implemented as follows. The factors considered by the Charity Commission when a charity requests to change its charitable purposes will be applied consistently regardless of its legal status. For example, CIO, charitable company, or unincorporated charity. The Charity Commission will now consider the original purposes of the charity, the desirability of the proposed changed purposes to be similar to the original ones, and the need for the purposes to be suitable and effective in the light of the current social and economic circumstances. Where there is uncertainty as to whether a trustee was properly appointed, casting the doubt on the validity of such appointment, the Charity Commission will have a new power to make an order to ratify the appointment or election of a trustee. Where a charity converts to a CIO or mergers, the new Act will make it easier to transfer charity assets via a vesting declaration and can remove the need to keep a shell company open to catch any of the legacies after the event. If you would like any further information on how Charities Act 2022 will impact your charity, please get in touch.